The organisation Undoing Tax Abuse says while Advocate Andy Mothibi's appointment as NPA head wasn't transparent, it was driven by the urgency to fill the role. Law firm Xulu And Partners is challenging Mothibi's selection. They claim there was procedural unfairness in that decision. President Cyril Ramaphosa, you may recall, appointed Mothibi directly after an advisory panel failed to recommend any of the 6 shortlisted candidates interviewed. He replaces outgoing, well, she's gone now, Advocate Shamila Batoy, whose tenure concluded last week. Let's talk to Barnabas Xulu from Xulu And Partners Incorporated. Barnabas, good morning. Thank you very much for your time. We appreciate it. Maybe just a quick update. We understand those papers were served on Andy Mothibi's first day in office yesterday. Just talk to us about what you understand about how that process unfolded and whether there has been a response.
Well, no response at the moment. Good morning, and good morning to the viewers. No response at the moment that we have received on the service of the papers, but Sheriff was instructed to serve these papers urgently yesterday. So we await the return of service on the service of those papers.
One of the things you've been clear about, Barnabas, is that your legal action now is not about the competence of Advocate Andy Mothibi. What, in your view, though, is going to the heart of the issue that you're raising insofar as a procedural flaw that makes, from your perspective, this appointment unlawful?
First and foremost, I need to make it clear that we stand firm on the importance of applying the fundamental principles of our law in its rationality and the just application at all times. In this case, we should be doing that without fear or favor. The challenge and prejudice, in fact, but the challenge that we have put forward is definitely not against Advocate Mothibi, the competence of Advocate Mothibi, but the challenge that we have is on the process that was followed, and we're very clear that that process, when it was followed, it never gave a fair hearing to Advocate Cronje to an effect that our objection, which was very serious, was ignored. So those are the simple kind of criticism that we have on the legality of the process itself, how the panel handled. And we're saying this panel was more of an extension of the president. It was actually the president that was undertaking that process. The process at the time when he made the appointment was subjected to a court process seeking to interdict it. And he could have done a simple thing in respect of the law, to respect the rule of law, by merely appointing someone acting in his position and carry on with a new process that was going to be a legal process, which is respecting the rule of law. But instead, he made the appointment, and now we're saying that appointment, which was made during that period, was irregular and it's unlawful. We are guided.
Yeah.
In this case, we are guided by Section 179 of the Constitution and Section 10 of the NPA Act that talks about the integrity of this process. And this process definitely was not above reproach and was not passing the legal muster that is demanded by these constitutional principles and sections in particular.
So, I mean, you were referring there to Hermione Cronje, who was, I think, part of the group. Well, she was instrumental in launching the investigative directorate at the NPA. It is her candidacy, you say, that wasn't given a fair hearing. Let's go back then to the procedure, Barnabas, around the appointment itself. And in the aftermath, actually, of the appointment of Mothibi, the question was asked about why go through this extensive public process and then land on a candidate also who is 2 years away from retirement. But the response that we got from the presidency was, and I think you've touched on it lightly there, that the president does have the constitutional power to appoint an NDPP. Are you going to ask the court in some way through this action to limit or reinterpret presidential discretion?
That is correct, because I can say now, as a matter of fact, that if Advocate Mothibi was subjected to an interview process, there was definitely going to be objections against him. And this process is at least allowing the public to join, or the members who are interested in this process to join and use this opportunity to raise their objection against Advocate Mothibi. But because, in a way, he was shielded by not participating in the process, the public who were interested in raising objection against him were denied that, as a matter of fact. But this process now, which is the legal process, will give the members of the public that has got objections, which I mean, he cannot be. I mean, we know of the candidate that participated that had vigorous scrutiny by the panel, and that vigorous scrutiny by the panel arose out of the objection that were raised by members who were interested in the process. I mean, this process needs to be beyond reproach. So in this case,
I want to clarify. So sorry, Barnabas. I want to clarify what appears to be a little bit of a mixed message. So I'm giving you the opportunity to just state exactly what the meaning is. Because at the outset, you said you don't have a personal issue with Mothibi. On the other hand, you've just said that had he been subjected to that intense scrutiny that the other 6 candidates were subjected to, you would have raised objections. And my question would then be, what objections would you likely have raised?
Well, I'm not, maybe those will be raised in the court papers, as I said. This is not right now the panel interview. And I cannot be raising the objection that will have been raised in Mothibi's, because I'm not the right forum for that. But I'm saying this gives now members of the public that have got interest in the integrity of this process a right, for instance, to join as friends of the court and raise those objections if they have. Now, because he's an individual and a professional who's got a long history, I don't have any issue with his competency as such, but I cannot vouch and say he was not going to be receiving objections like the other candidates have received the objections. That's what I'm saying. And you see, and that is why in my opening, I made it clear that this is not an anti-Mothibi campaign, and it should not be used as such, because it would be very dangerous. People must be careful, because the next thing is I'll be receiving the objections on Mothibi, because this is challenging the president's decision in relying on the panel that was under challenge and then appoint a different candidate that was not subjected to the process.
I'm going to try and go efficiently because there's some really important themes, Barnabas, I'm hoping to get to before we conclude our interview. Talk to us about the legal grounds on which you challenge the president's authority.
I'm not challenging the president's authority. That's another big mistake that people also make. It's the process, the fairness of the process that lacked integrity. And I'm very clear in terms of where exactly this integrity was flawed. And it's the basis of asking for the record so that we can even supplement. The clarity is when Advocate Cronje was supposed to be attending to the objections like all other candidates, she was somehow shielded. In fact, it's on record, it was public, when she denied having received the objection, or the objection that was raised by our firm. And every other candidate, I mean, there are candidates that received more than 200 objections, and they were scrutinized, they were put under public scrutiny. Now, she was not done, and that, we're saying, created a serious flaw in the process integrity, which is similarly applicable when it comes to Advocate Mothibi.
Yeah.
I'm aware I'm aware that the president has got these prerogatives which are conferred on him by the Constitution, but we need to borrow from the provisions of the Constitution that talks about without fear, favor, and prejudice. In this case, in particular, Section 179, in this case, Mothibi is now favored by not going through the process.
Right.
That brings in the legal question as to, can you rely on that process? In fact, the process, he could have started a new process altogether. He could have made someone to act whilst the process is being, there was no rush, in other words.
And you know, part of the other suggestions were that he should be starting this in the next 7 years or however, whenever, or the next, well, let's see what the time frame will be. Start the process much earlier to allow for this eventuality that there might be an issue. But it sounds like multiple issues are being raised here, Barnabas, by your legal firm. It is the conduct and the work of the panel itself. And then also, because you say you're not challenging the president's authority, but there are issues related to the fact that he ultimately does have the final say. I mean, we're given the impression that actually holding a public review was at the pleasure of the president. It's you know, it wasn't. It was his prerogative to choose to do that or to forego the process. So we'll see how that piece plays out in court. If the court rules in your favor, let's say, and you can talk to us about how you see it unfolding, what practical outcomes are you hoping for? A reversal of the appointment?
Yeah, first and foremost is that I'm expecting that there are people that are going to be joining in as friends of the court who will be raising now objections on Advocate Mothibi. Once that is done, then it opens up now for him to be scrutinized, at least this time around by the court, whether was he a right candidate as he was shielded. So that's one of the things which, I mean, I cannot adjudicate. I'm not a judge here. I cannot adjudicate on that matter and come to a conclusion. But the reliance on the application of law, which, as I said, the rationality and just application at all times, is a material fact. Courts are expected, when they adjudicate also, to observe that status, that measure when they are executing their duties as presiding officer.
Okay. Barnabas, in 10 seconds, who might join as amicus curiae or friends of the court?
It may be too early to say. Let's see when the record is provided and we have now properly laid out our case.
Okay.
People will be interested when they see that record being provided, whether it is a record that is reflecting exactly what transpired during the process, and if it does not, I mean, that is going to trigger the interest. Okay. I can see now. I mean, I'm alone in this challenge.
Okay.
But I'm confidently telling you, as a matter of fact, that this opportunity will be grabbed by those who lack the democratic South Africa to be operating under the Constitution and observing the tenets of our wonderful Constitution, that they will be becoming part of this so that they see that justice is done.
Okay. Thank you for that, and thank you for making yourself available. We appreciate it. Barnabas Xulu is from Xulu And Partners Incorporated. We're touching on the final hour, the 8 o'clock hour. Do stay with us.